All right, thank you. So we're here today, Legal Resources for the Elderly program, to talk about some common legal issues that affect senior citizens. So like I said, my name is Natalie. I am one of the staff attorneys here with the program. A little bit about us. We are a joint project of New Mexico's Aging and Long-Term Services Department and the State Bar of New Mexico. And you'll see here at the top is ways that you can contact our program. We have both a statewide line, a local line, and you can also find a lot of our materials and publications and videos online. So I will mention that throughout the presentation where you can find some of this information online. So our program is a free statewide legal helpline for New Mexico seniors 55 and over. Our attorneys advise on a variety of civil legal issues, such as powers of attorney, estate planning, Medicaid, and much more. Our program has no income restrictions. So what you do to speak with one of our attorneys is you will call up the program and complete an intake, and one of our staff attorneys will be in touch with you to discuss your legal issue. We can also speak with third parties as long as we have your permission to speak with someone else. However, when it comes to estate planning questions, we want to speak with you directly. So we won't speak with anyone else about your estate plan. That's your business. So some of the common issues that we'll be talking about today are powers of attorney, probate, and Medicaid. First, we'll be talking about powers of attorney. So deciding who decides for you when you no longer can make decisions. First, we'll be talking about the financial power of attorney. So this document allows you to name an agent who can handle your finances. And the importance of this document is without a financial power of attorney in place, if something happens to you and you can no longer make your financial decisions, unfortunately, no one will have legal authority to do so. And in that situation, a family member or friend would have to petition for guardianship or conservatorship in the courts in order to have that decision-making power or authority. With your financial power of attorney, when you decide to name an agent, you want to make sure that you're naming someone that you trust, obviously, since this is your finances, but you also want to name someone who's available. Oftentimes, we'll speak with clients who have children who are living in other states. They'll have, a son or daughter who's really savvy and into finances, and they live in New York or California. And certainly they'll probably be a great person to handle the job when the time comes, but you want to make sure that they're going to be available when the time comes to handle your day-to-day finances. Some options with your power of attorney, your financial power of attorney, include naming successor agents. So if your first choice isn't available, you can name alternates who can step up and make those decisions on your behalf. You can also authorize your agent to pass that power on to someone else. So this is a good way to ensure continuity of your care and your finances. There are two different kinds of powers of attorney. The first is an immediate power of attorney. So if you execute this document, you name an agent, and it's an immediate power of attorney, that person can take this document to the bank and start transacting on your behalf right away. With a springing power of attorney, this document actually does not go into effect until you lack capacity. And so we get a lot of questions about what it means to have capacity. And so when we talk about capacity, we're talking about the ability to understand the decisions that you're making and the documents that you're signing, the ability to make decisions and understand the consequences of those decisions, the ability to communicate these decisions to other people. And oftentimes when we're talking about capacity, this is something that's determined by your healthcare professionals. There are some limits on the financial power of attorney. The first is that it must be in writing and it must be notarized. The good news is that you can revoke a financial power of attorney at any time. However, if you revoke this document, it must be in writing and it must also be notarized. It's important to note with the powers of attorney, both financial and healthcare, they're only good while you're alive. You can only grant somebody authority to act on your behalf while you're living. Once you pass away, that power that you granted your agent ceases to exist and the document is no longer valid. A lot of people mix up powers of attorney with estate planning, who gets to handle your estate at your passing. And those are two separate kinds of planning. So a power of attorney is not a substitution for your estate plan. As a reminder, as we advance through the presentation, if you have any questions about any of these topics, please type them so that we can answer them at the end. Moving on to the next power of attorney, this is your healthcare power of attorney. It's known as the Advance Healthcare Directive. And so the Advance Healthcare Directive has 3 optional parts. So you can fill out as much or as little of this directive as needed. The first section is your power of attorney section for healthcare decisions. This is where you will name your choice for agent, much like your financial power of attorney. You can also name successor or alternate agents in case your primary choice is unavailable. In the second section, this provides instructions for your agent in regards to your end-of-life care. And so this section used to be called a living will. And I think that's why some people will confuse powers of attorney with estate planning. It's because they think of a will, and so they're thinking of estate planning, but the living will is referring to your end-of-life care instructions in your healthcare power of attorney. In this section, you can also indicate decisions about whether or not to prolong your life. If you do decide to prolong your life, you can elect what methods by which to do so. So you can, this includes artificial nutrition and hydration. You can also indicate in this section whether or not you wish to be an organ donor. And I know a lot of people will ask, well, you know, it says on my driver's license that I want to be an organ donor. Is that not enough? And certainly that's good. What I recommend is making sure that your power of attorney, your healthcare power of attorney, and your driver's license match to ensure that the right decisions are made. For all of these end-of-life care instructions, you can also elect to let your agent decide. So what I tell clients who are looking to complete this document is that if they have very strongly held beliefs or ideas about what they would like for their end-of-life care decisions, to make sure to complete this section. However, if they feel that their agent is going to be in the best position and have the most knowledge about the situation, perhaps it's best to let your agent make those decisions. Finally, the last section of the Advanced Healthcare Directive is the primary physician section. So in this section, you can name a primary physician. I often get questions when people are filling out this document about what they need to put there, especially with changing insurances and healthcare providers. Sometimes you don't have a primary physician, and it's okay to leave this section blank. Although I will tell people if they have a rare condition or disease, or if they've had a very lengthy treatment history with a particular doctor, you might want to make sure to put that doctor in as your primary physician, since they're going to know the most about your condition. With the Advanced Healthcare Directive, your healthcare power of attorney, there is no need for it to be witnessed or notarized. So this is a major difference between the financial power of attorney. The financial power of attorney requires a little bit more of the document. It must be signed and notarized. Your healthcare directive does not need to be notarized. However, you will see we have a note here that it's a good idea to notarize your Advanced Healthcare Directive if you're traveling out of the state often. And this is because different states have different requirements about what documents need to be notarized in order to be valid. So especially here in New Mexico, where we border with several states, if you find yourself traveling often, be sure to have this document notarized. The good thing about the Advanced Healthcare Directive is that you can make changes at any time, and a copy is just as good as an original. So we encourage those who are executing their advanced healthcare directive to give copies to your doctors, your providers, family, your agent. With the advanced healthcare directive, if you don't have one, the law actually sets who decides for you. So this is a major difference between the financial power of attorney. Without a financial power of attorney, someone is likely going to have to petition for guardianship or conservatorship to make financial decisions. However, with your advanced healthcare directive, if you don't have one, the law designates people who can step up and make decisions as a surrogate decision maker. And so generally, they're going to look first to a spouse or a longtime partner. If none of those are available, then they'll be looking to adult children. If there are no adult children alive or available, then they'll be looking to parents. If the parents have already passed away, they'll continue so on and so forth until they can find someone who is familiar with you and your beliefs and can make these healthcare decisions on your behalf. As a reminder, please, if you have any questions about the powers of attorney, type them in so that we can answer them at the end. So the next section that we'll be talking about, a common issue that we talk about with seniors, is probate. So what happens to your property when you die? And so we are often asked, what is probate? And so probate is the legal process to transfer assets and pay your debts after your passing. A personal representative is elected and takes your estate through the probate court. However, if you use non-probate transfers, there will be no need for probate for that particular piece of property. And we're going to talk more about non-probate transfers much more in depth in a moment. Another common question we get when we're talking about what happens to your estate when you pass is, do I need a will? And so with a will, you get to determine who gets your property, and you can also choose who is going to be the personal representative. Without a will, without any kind of estate planning, intestate succession law or your inheritance laws will determine how your estate is handled. And so generally that means that property is going to go to your closest relatives in equal shares, and they will have to agree on a personal representative, or if they can't agree, a court will make that decision for you. Now with non-probate transfers, you get to say who gets to receive your property at your passing. So this is a decision you're making while you're still alive. And because you've used a non-probate transfer to determine who will get your property, there will be no need for probate in regards to that particular piece of property. So any kind of non-probate transfer means that it's not going to be handled in probate later. You've already made the decision. So let's talk more about these non-probate transfers. So these are transfers of assets without a will or going through probate. One of the common ones that we'll talk more about is joint tenancy. So putting someone's name on the deed or the title to the home. Here in New Mexico, we have what's called a transfer on death deed that allows you to name a beneficiary for real estate. And we're going to talk more in depth about that as well. For your bank accounts, you can designate them as payable on death, and your beneficiaries will receive those funds at your passing. For stocks, investment accounts, you can make them transferable on death, and your beneficiaries will take those funds at your passing. The same is true for insurance, annuities, retirement accounts, any kind of investment that you can name a beneficiary on. This is considered a non-probate transfer. They'll receive those funds at your passing. Trusts are also considered a non-probate transfer. However, I will say in regards to trusts, a lot of people think that they need them, but they're increasingly less popular, and that's because they're very expensive to draft and maintain, and generally they're only needed in situations where you have a very large estate worth millions of dollars, or for example, if you have property in another state, or if you're looking to have children from a previous marriage perhaps inherit, or if you have an adult child who is disabled and receiving state benefits, that might be another reason for a trust. Otherwise, it's very likely that you can plan your estate through non-probate transfers or a will in a much affordable way. And so you'll see here in bold on this slide that any property transferred by the above methods, by these non-probate transfers, is not distributed according to your will because that property is no longer a part of your probate estate. When you use these methods of planning, you've already made decisions and it's something that won't be addressed in your will or in probate. So it's a good idea to make sure that all your papers match if you have a will and you've done some of these non-probate transfers. So one of the non-probate transfers that we highlighted was joint tenancy. And in our program, we often see joint tenancy with a non-spouse. So we will have people putting their children on the deed to the home or on their bank accounts. And so we always caution our clients against doing something like this. And the reason is that when you add them to the deed or the account, it gives that person joint ownership power over the asset right now. They could go to the bank and withdraw money. They are now an owner of the property. So this also means that as a joint owner, their creditors have access to these assets. So if you add, say, your son or daughter to the deed or account, and they get into some financial trouble and they're sued by a creditor for a debt, that creditor could potentially come after this asset that you guys are now joint owners of. It also means if you do something like putting your children on the deed to the home or a bank account, that it could make you ineligible for Medicaid for long-term care in a facility or in the home because it is considered a transfer. So it's very important when we're talking about joint tenancy that you think very carefully about this. I can think of one example where a client had called us and she had decided to put, I believe it was her niece, on the deed with her in joint tenancy. And the niece was living in a different state. And when the roof started leaking, our client asked the niece to sign off on some financing so that repairs could be made to the roof, and the niece refused. The niece suggested that perhaps our client should just put some buckets where the roof is leaking. So you want to think very carefully about who you enter into a joint tenancy with, and oftentimes we advise clients it's just not a good idea. So another kind of non-probate transfer is the transfer on death deed. And so this is something that's unique to New Mexico and a few other states. What this is it allows you to transfer New Mexico real estate to a beneficiary after your death. And one of the advantages of this deed is that you, as the owner, you get to keep title and control while you're alive. So you execute this deed and you sign it. You'll record it at the county clerk's office where the property is located. And title actually doesn't transfer until after your passing. The good news is with this particular deed, you can revoke the deed and execute a new one. So if you've changed your mind about the beneficiary, you can absolutely execute a new deed. Because you maintain title and control, you can also sell the property, borrow money against it. Obviously, if you execute one of these deeds and you sell the property, the deed will no longer be valid. A little bit more on the transfer on death deed. So as I've been emphasizing, the beneficiary that you name to receive this real estate can't take the property or borrow money against it until after your passing, and that's because they don't take title to the property until after your passing. It's important to note, because this is a non-probate transfer, this property will not be a part of a probate estate. So this document is going to control over a will, and it's not going to be a part of probate. The advantage of a transfer on death deed is that because there's no transfer until after your passing, it won't affect your Medicaid eligibility because there is no transfer until you've passed. With a transfer on death deed, it's not advised to execute one of these deeds if you're looking to leave the home to multiple beneficiaries. And that's because all of the beneficiaries will have to agree on what's to be done with the property. So we often say, if your kids can't decide where to go to dinner, I bet it's probably going to be difficult for them to decide what to do with a property when there's many people that all have to agree on what's to be done. As a reminder, please, if you have any questions, be sure to type them out so we can answer them at the end. For our final section, we're going to be talking about Medicaid, and this is how you can pay for long-term care. So it's important, I believe, to discuss the difference between Medicare and Medicaid. We have a lot of clients that will call us up and they're a little confused between the two programs. So with Medicare, this is the insurance that you pay for through Social Security. It's available for those who are 65 or older or those that are disabled. And Medicare covers only short-term skilled care in a nursing home, but not custodial care. So your custodial care is your day-to-day care. Skilled care, what we're referring to in that situation is care by a skilled professional who has education and licenses, your occupational therapy, your physical therapy, that kind of skilled care. With Medicaid, this is a government benefit for people who can't afford their long-term care. And so Medicaid does include custodial care, but there are income and asset tests in order to qualify for Medicaid. So let's talk a little bit about those income and asset tests. For Medicaid, as a person applying for the program, you can have a monthly income limit of up to $2,349. As the person applying for Medicaid and going into the nursing home, you're allowed to keep $78 a month for personal needs. And I know a lot of clients and other people that we speak with are very alarmed by that. But when you look at the average cost of nursing home care and what the rest of your monthly income goes to pay for that care, the average cost is $7,485 a month. And I'm sure that figure is going up. So you can see how quickly your income will be used to pay for your care in the nursing home. If your income is above this monthly limit, we encourage you to contact our program. There may be ways to still qualify for Medicaid through what's called an income diversion trust. And this trust basically captures any excess income above this monthly limit and puts it in a trust that eventually goes to reimburse Medicaid. And this allows you to qualify for Medicaid if your income is over the limit. With any Medicaid questions, we always encourage people to call our program so we can discuss your situation and what might be best for you in order to qualify for Medicaid. So in terms of assets, a single person applying for Medicaid can have $2,000 in a non-interest bearing account. You can also have $1,500 in a burial account or a prepaid burial agreement of any value. You can also claim a car of any value. And for a single person, you can claim a home with up to $595,000 worth of equity, so almost $500,000 worth of equity. It's really important if you are applying for Medicaid that you check the box that says that you intend to return home. And while the reality may be that you're going into the nursing home and you will never return home, it's still something that you need to do. If you don't check this box, all of the equity in the home will count as an asset against you. So it's really important that you check that box and let one of these assets be your exempt home. It is possible, as you can see here, that a estate claim could be made However, in practice, we haven't seen Medicaid making estate claims in a really long time. Obviously, things may change, but at this time, estate claims aren't something that we are seeing happening in regards to Medicaid. For a married person, so you have one spouse who is staying home and one spouse that is applying for long-term care Medicaid, the spouse that remains at home actually gets to keep a little bit more. So they get to keep 1/2 or more of the couple's monthly income. They can claim a house of any value, a car of any value, and they can also claim up to 1/2 of the couple's other assets, a minimum of $31,000 up to a maximum of $128,000. However, if both individuals in a marriage, if they both have to apply for Medicaid, each person will be treated as a single person applying for Medicaid in that situation. So it used to be back in the day, if someone needed to qualify for Medicaid, they would go ahead and give away all their assets, gift things to their grandchildren. However, the federal government caught on to that. And now for those applying for Medicaid, there is what's called the 5-year look-back period. And so what this means is that there will be a penalty for those applying for Medicaid if they find that you've given away assets within the last 5 years, so the 5 years preceding your application. And if they find that there's been any gifting or transferring, you'll be disqualified for a time equal to the value of that asset that was transferred or gifted. And that is the amount of time that it would pay for your care in a facility. And it's at a rate of approximately $6,000 per month. It's important to note that just even putting someone's name on an account or a deed is considered a transfer. So if you're in a situation where you're looking to apply for Medicaid and you have a lot of assets, the alternative in order to qualify for Medicaid is to spend down those assets on yourself. There is no penalty for spending down on yourself. And you'll also see there's no penalty for a transfer between spouses. So if you have excess assets and you're looking to qualify, as long as you're spending down on yourself, that's permissible. And some of the common ways that we talk to clients about spending down, especially those where a married couple has one of the spouses applying, you might want to think about that at-home spouse. Does the home need a new roof? The vehicle that that spouse will be driving to come and visit you in long-term care, could they perhaps use a new vehicle for transportation? As long as you're spending on yourself, that kind of spend down is permissible. So this is the end of our presentation. As I mentioned at the beginning, I wanted to highlight that we have a lot of information on our website. So if you go to nmbar.org/LREP, you can check out our publications tab has all of our information. So in our publications tab, we have videos about powers of attorney, which we discussed at the beginning of this presentation. So we have more in-depth videos about those documents. And we also have the power of attorney forms available to download. So both the Advanced Health Care Directive and the Financial Power of Attorney. And we have videos that walk you through how to complete those power of attorney forms. You will also find we have a variety of senior supplements or one-page flyers on a variety of topics, including Medicaid and probate and estate planning, which we discussed today. So I will take any questions if we have any.
All right, Natalie, we have a few questions here. First, does a will have to be drafted by an attorney, or what options are there for getting a legally valid will?
Yes, this is a question that we speak with clients about a lot, and we always recommend that you do have an attorney draft a will. And that's because there are certain requirements for a will. But also you want to make sure that it's drafted correctly so that the people that you want to inherit your property actually do. If you try and draft a will yourself and it's done incorrectly, you may find when you go to probate to have the courts distribute the estate according to your will, you may find that the will is invalid, and then you're looking at intestate succession laws, your inheritance laws, to determine who gets your property. So we always recommend hiring a private attorney to draft a will. I will say though, as you saw in our presentation, there are other ways to plan your estate such that you might not need a will. So we always encourage people to give us a call so we can talk to you about your particular estate and perhaps give you some advice and perhaps let you know if you even need a will in the first place.
All right. And the next question is, can a transfer on death deed be executed without an attorney, or is there other assistance such as samples that you can follow?
Much like the will, when it comes to a transfer on death deed, once again, we recommend that you have an attorney draft it, especially because in regards to legal descriptions, if you get even a capital letter incorrect, it could make the deed invalid. And it can also put a cloud on the title, which can make it difficult for whoever's looking to inherit the property. It can cause some problems for them later on. I do know that there are sample forms out there online, and some stores allow you to purchase forms like wills and transfer on death deeds. But we always say it's best to have an attorney draft that document and review that document to ensure it's accurate and that it's valid so that your heirs don't have any difficulties at your passing.
Okay, and that is pretty much it. There was a final question about whether this webinar can be viewed again somewhere else.
So hopefully we have recorded this webinar. We did intend to record this session and plan to place it on our website. So you'll find it at nmbar.org/LREP. And under our publications, we're hoping to put this video up on the website. I'm not sure how soon it'll go up, but we do intend to post this. I also believe, and our Bill can answer this perhaps for us, I believe that the slides from the presentation are also available to participants. Correct me if I'm wrong, Bill.
Yes, I meant to mention that at the beginning. On the control panel, you'll see a box marked handouts, 1 of 5. There's actually only one handout, but if you click that box, you should see a copy of these that you can download and print out at home.
So yes, we hope to have this webinar available. We're also hosting this webinar monthly, so if you wish to attend in the future, you can certainly watch out for your email. I believe we're sending out emails monthly in regards to our webinars, so you can absolutely attend again if you'd like to come and watch again, or if you have other family members or friends who would benefit from this information, you can tell them about our webinars. And with that, I would like to thank you guys for listening today. And certainly, if you're a senior over 55 and you have some questions for our hotline, please give us a call. Hopefully we can give you some advice and point you in the right direction. Thank you guys so much.